The Supreme Court has a case sitting right in front of them that could strike down all assault weapon and magazine bans nationwide, and they could do that right here and now. This critical case is called NAGR v. the City of Naperville, and it is a challenge to a city ordinance which banned the sale of so-called assault weapons and also large capacity magazines. This lawsuit is also a challenge to the state of Illinois' law, which also bans the purchase and sale of rifles and magazines. And right now, this case has been submitted to the U.S. Supreme Court, and Justice Amy Coney Barrett has demanded that the city here and also the state file a response and defend the constitutionality of their bans. This means that the Supreme Court is in fact interested in considering a case which ultimately deals with a ban on so-called assault weapons and also magazines. Now, before we dive any further into this, I just wanted to thank everybody for supporting the channel and for everybody who helped me to reach 500,000 subscribers. Thank you so much. And also, if you're not currently subscribed, please consider subscribing to the channel and help us in our effort to hit 1 million subscribers. Also, I want to thank USCCA for sponsoring this video. If you guys concealed carry, you also need to consider what happens if maybe you have to use your firearm self-defense. USCCA provides you with legal protection in case you find yourself in that type of unfortunate event. So if you're interested, check out USCCA using the link down below. Now, you may be asking, how did we get to this point and what are we talking about here? Well, the Supreme Court is now at the point where they are considering a case which deals with a city and state ban on so-called assault weapons and also large capacity magazines. On August 17th, 2022, the City Council of Naperville, Illinois, enacted an ordinance that bans the sale of rifles and magazines within the city. The ordinance also puts in place substantial penalties for anyone who violates that ordinance. Now, on January 10th of 2023, the state of Illinois passed their own state level law, and that regulates the sale and purchase of rifles and magazines. And that also has a restriction on magazines, like I mentioned. They call them so-called large capacity magazines. But essentially, that definition means that any magazine that is capable of accepting more than 10 rounds of ammunition for long guns, and then also 15 rounds of ammunition for handguns. The plaintiffs in this case filed their challenge to that ordinance and the state law, which banned these types of items. In this case, the plaintiffs also filed for a motion for preliminary injunction. A preliminary injunction is a way to temporarily halt the enforcement of a law, and it's a temporary halt until a trial is ultimately fully done, till the case is fully resolved, either through a trial or something like a motion for summary judgment. Ultimately, though, on review, the district court denied the plaintiff's motion for preliminary injunction. The plaintiffs then decided to appeal that denial by the district court up to the 7th Circuit. And in doing so, they also sought for the 7th Circuit to issue a temporary halt on the enforcement of the law until the appellate court could review the case. Now, on review, the 7th Circuit also denied the request for an injunction. And that has led to the plaintiffs now seeking an emergency immediate review, an emergency application up to the Supreme Court. The plaintiffs filed an emergency application for injunction pending appellate review. In simplest terms, what this means is that the plaintiffs want the Supreme Court to step in and to find that the district court and the 7th Circuit should have granted their injunction in this case. And therefore, what they are requesting is for the Supreme Court to issue an injunction on their own. However, the Supreme Court stepping in and doing that would also send a huge signal to the entire nation. It would essentially be the Supreme Court saying to all states, all cities, all governments, that they are not going to uphold these types of bans on rifles and magazines. And that's why this is so important and very interesting. Now, the question presented to the Supreme Court in this case is, can the government ban the sale, purchase, and possession of certain semi-automatic firearms and firearm magazines, tens of millions of which are possessed by law-abiding Americans for lawful purposes, when there is no analogous historical ban as required by DC v. Heller and New York State Rifle and Pistol Association versus Bruen? In this petition, the plaintiffs argue that the lower court simply got this issue completely wrong and should have granted them their injunction. They argue that instead of using the common use test in Heller or historical analysis as outlined in Bruen, the district court leaned on something that was completely made up, which was particularly dangerous weapons. The plaintiffs argue in this case that dangerous and unusual was established in Heller and also is mentioned in Bruen, but this type of particularly dangerous test or dangerousness test that the district court was using is not what is actually outlined in Heller and Bruen. Instead, they say that in Heller and Bruen, this court was contrasting weapons that were in common use from weapons that were unusual. In other words, it was the unusual part of the phrase dangerous and unusual that was relevant to the court's discussion, because that is what contrasted the prohibited weapons from weapons that were in common use. It is this use of this made-up test that the plaintiffs are arguing makes the district court's decision to deny their injunction incorrect, and that the Seventh Circuit should have seen that, and at the very least, the Seventh Circuit should have granted the injunction. That is why the plaintiffs are now requesting for the Supreme Court to step in on an immediate emergency basis and enter an injunction on their very own, restraining the enforcement of these laws while this case makes its way through the Seventh Circuit Court of Appeals. Now, this emergency application is similar to what we saw GOA do with their Antioch case, which dealt with the state of New York CCIA law. In that case, the Supreme Court ultimately denied the emergency application, but we did get an order from Alito and Thomas in that situation. And there they told the Second Circuit that they could not just flippantly deny a request for a stay. Instead, the Supreme Court said that the Second Circuit either needed to issue a full order with all of their rationale for why they are denying the stay, or at the very least, they needed to expedite the hearings. And what that forced is for the Second Circuit to expedite all of those New York concealed carry cases. Now, here in this city and state assault weapon and magazine ban case, the emergency application was submitted to Justice Amy Coney Barrett, since she is the justice responsible for granting, denying, or referring emergency applications that come out of the Seventh Circuit. However, what's interesting and it's got everybody really intrigued with this is Justice Amy Coney Barrett has in fact demanded that the city and state of Illinois respond to the emergency application. That means she is demanding that the state here, the city here, answer why they believe the application, the emergency application, should be denied, why they believe the assault weapons ban and the magazine ban that they have in place is in fact constitutional, and how they believe the lower courts were correct in denying the plaintiffs' injunctions. Now, if you were to ask me what will happen, the likelihood is that Justice Amy Coney Barrett may still deny the request even though she's seeking a response. She can still deny it on her own if she wants to. In that situation, though, NAGR could go to any of the other justices that they want on the court and ultimately seek emergency review. However, at that point, it's kind of interesting because you would already have one conservative or right-leaning justice who's denied your review. That means that you've already lost one of those judges. So it would be kind of weird to go to another one, but they can still go to Thomas if they wanted, or Alito, to seek emergency application. Most likely, Justice Barrett will in fact just refer this to a full court review, and then you will need at least 4 justices who want to take this up and agree that they want to take this up on an emergency basis. However, I do want to note that traditionally, the Supreme Court does not like to take interlocutory cases and appeals like this, and that's what we're dealing with because this is a preliminary injunction rejection. And what they're asking for is for the Supreme Court to step in on an interlocutory basis, really. The Supreme Court prefers to take final resolutions, summary judgments, or final case determinations. Lately, the Supreme Court has been very hesitant and has deferred to the lower courts and has given them opportunities to hear these cases before stepping in, like they did with the Antioch emergency application. But there could be a situation where even if they deny the application here in this case, they could still issue an order, maybe through Thomas or Alito, like they did in Antioch, where maybe there's some sort of language that then helps us to fight all these other assault weapons bans in other states like California, Washington, etc., and also magazine bans. So that's why this is so interesting. It's interesting that Amy Coney Barrett has requested a response, and it's also interesting because even if they deny this, there could be some language that comes out of this that helps to expedite all these other challenges. Whether or not they're willing to do that right here and now is yet to be seen, but that is what's going on right now at the Supreme Court level with them considering to review an assault weapons ban and a magazine ban. If you're interested in specifically what is going on in Illinois and their assault weapons ban and it being halted by a federal district court judge, you can watch this video here on the screen where I break all that down. But as always, I want to thank everybody for watching. Don't forget to like and subscribe, and never forget this nation was built by Armed Scholars, and this nation will be maintained by Armed Scholars.